Good afternoon and welcome to Legal Lunch with Laura. I want to thank you all for joining us on this snowy and blustery Tuesday afternoon. It seems that every institution is closed, but we are still a go and we're here. A reminder that this webinar has been pre-approved for one HRCI credit, and within a day or so after the webinar you will receive an email from me with the code for you to use on your recertification form for HRCI. You will also receive a link to this entire webinar so you can access it in the future and share it with colleagues, and it will also be posted on the Offit-Kerman website. If at any time you have a question, please type it into the box located at the bottom right side of your screen, and my guest Jim and I will do our best to answer questions as they're presented or hold them and answer them at the end of the presentation. I wanted to let you know about 2014 lunch dates with me. I'm looking forward to my next webinar where I plan to discuss legal updates and laws on the horizon, including bills such as increases to the Maryland minimum wage, paid sick leave, and a topic close to our hearts in today's webinar topic, which is proposals for eliminating employers' use of criminal background checks in employment decisions. So please stay tuned. The topic for our webinar today is using background checks to hire the right talent. So many of you have done it, I'm sure. You have cut corners and hired the wrong person. Why have you done it? Either you've missed something, you failed to review a report, you didn't have time to call a reference, you were understaffed, or you were desperate to just get someone in to get them started on the job, and you really didn't have a lot of time. So, you know, why is it important? Someone needs to be properly screened and vetted. They wouldn't have received an offer in the first place. And, you know, we've heard story after story about bad hires, which is why Jim Randisi and I now bring you to this webinar. So welcome, Jim.
Thank you, Laura. It's a pleasure to be here. Thanks, everyone, for attending.
Let me introduce everyone to Jim, this handsome fellow right here on the screen. Jim.
Photoshop.
No, not at all, not at all. Jim is the owner of Randisi and Associates, which has been in business since the late 90s and processes about 1,500 people per month, which is an extremely high number of background checks that they are running. Randisi and Associates has a mission to help firms protect not only their employees, but their clients, assets, reputation through employment screening and drug testing. They also help firms and companies keep out individuals who have falsified job applications, have histories of dangerous behaviors, and are using illegal drugs and alcohol. So again, welcome. Thrilled to have you here.
Thank you.
Jim, why don't you take this next slide and tell us why you recommend that employers screen their applicants.
Sure, Laura. Why should we do this? We think that it's best to associate with safer, competent people. Our focus has always been helping organizations avoid people who are falsifying their company's application. Perhaps they've engaged in recent dangerous behavior and are using illegal drugs. So you want to attract people who are honest, hardworking folks, and you want to avoid association with people who have had dangerous behavior in the past. Most of the times we believe people don't change their future behavior. They behave as they have in the past. And now, having said that, of course, companies should have a system of checks in place that assure any identified dangerous behavior, particularly with criminal convictions, have been properly vetted with the EEOC guidance.
Great.
And so we think if you do this, you're going to increase the quality of your workforce, and you're going to defend. We're going to talk a little bit later about negligent hiring, but you're going to defend against the tort of negligent hiring if one of your employees or volunteers, we do a lot of screening for nonprofits, volunteers, if they injure a third party, you don't want, not you, but your clients, folks listening, don't want to be in front of a plaintiff attorney and a jury answering the word nothing to being asked if they've done anything to vet the person that they're bringing into the workforce.
You know, you mentioned volunteers, and that wasn't something that we had specifically included in here to talk about, but I think it's a very good point that you raised, which is companies are liable for their volunteers. So it's wonderful if you have a large group of volunteers eager to provide services for free, interns included, volunteers, but if those folks are dangerous,
if they injure a child,
if they injure a child, if they injure another employee,
right.
if they sexually harass someone, if they make a defamatory statement, the company is liable. So I'm glad you brought that up. Another interesting statistic that you had was that one illegal drug user can cost a company about $13,000 by increased use of the employer's health program, including lost work time, accidents, and of course workers' compensation claims. So I thought that was an interesting statistic, which you had on your website.
Yes.
Yes.
We're going to be talking about that later. So
excellent. Right. Okay. So there are various background checks, and let me just go through very briefly what they are. And by the way, to answer your question, Laura Bond, yes, this webinar is recorded. For those of you whose offices are closing early, including ours, which just closed about 5 minutes ago, this is being recorded. So if we certainly understand safety is paramount if you have to leave. So getting back to various background tests, what are they? So there's a credit report. Okay. Credit reports are obtained through a credit reporting agency. There are 3 major credit reporting agencies, Equifax, Experian, and TransUnion, and we'll talk a little bit later about the Fair Credit Reporting Act. Criminal background checks. Criminal background checks show arrests, convictions, adjudications, and we'll talk in more detail about those. Employment history. Employment history is extremely telling. You always want to check and verify someone's prior employers, look at comparing their resume to an application. Education. Did they really graduate from Stanford? Did they really go to Harvard Law? How much are you, requesting that employees provide?
Education is the most falsified piece of information in an application.
And you see so many politicians and public figures who get caught after they're in office or while they're running for office because they have falsified their education or even military record as well. References, both professional and personal references, are sometimes, and I'll ask you this, Jim, sometimes people say, well, why would I ever check a personal reference, because I know they're just going to give this person a glowing reference anyway. Any response to that?
We find that professional references are much more valuable than personal references. So exactly for the reason you just said.
Right.
You're not going to give someone
biased.
Yeah. You're not going to give someone who's going to say something bad about you. So.
Right. Usually someone might put down their brother-in-law or sister-in-law that has a different last name. Right. Driving records, and these are primarily used when, of course, a primary duty or a secondary duty for someone's position is to drive or to operate a company vehicle or of course to be a delivery person. And then the Department of Transportation has its own requirements for someone who has to obtain a commercial driver's license or a CDL. Drug and alcohol tests. Big.
Yes.
Big. Both pre-employment, post-offer.
Mm-hmm. A drug test can be done pre-offer if you're looking for the 5 illegal drugs. No problem at all with doing that. If your drug test is going to test for additional panels other than the 5 illegal drugs, then best to do that type of drug test after.
Post-hire.
Post-conditional offer. Right.
Post-conditional offer.
Right.
And then, of course, what's not listed here is medical evaluations. So this is not something that Jim's company typically conducts, but medical evaluations can be part of a post-offer test where someone might have to have be cleared for certain medical conditions in order to qualify for the position.
Right. And just before we leave that slide, just two comments on the credit reports. A lot of people think that you see FICO score, and you do not see FICO scores on employment credit reports. And the driving records, very inexpensive and can be very revealing on people. So just some comments there.
Yeah, including that they don't have a license or it's been suspended.
Exactly.
Okay. Let's talk next about the beginning of the employment process, which is the application process. I usually recommend that in the application process, companies have all applicants complete an employment application, even if they've submitted a resume. An application requests additional factual information that's usually not contained on a resume. And for those who have put together a resume recently, you tend to kind of fluff it up a little bit, right?
Exactly.
You don't always explain your gaps in employment, or you fluff it over. So an employment application really gets to the heart of the factual history. So, Jim, when employers look at applications, what should they be aware of?
Well, listed here on this slide, Laura, are just some danger signals that we've seen, and sort of provided there as information for the attendees to the seminar. You want to look for things where they're trying to hide information from you, if they're not answering questions about criminal convictions, or if they're not signing the consent to do the background investigation. Individuals have set up companies for lawsuits by purposely not doing this, and then doing it, and failing to give information about where they worked. Someone will put McDonald's on York Road, and that's all they put.
And for those of you who don't know York Road, it's a very, very long road.
Right. And just the last point there: prior employers won't return our calls. This process is an investigation process, and the more information you can find out about someone, the better the decision is. So if prior employers aren't responding to this individual's requests for us to verify, then again, sort of an indicator of the type of person you might be dealing with. So.
All very good points, and I'm sure you've seen this many, many times along the way, and you've dealt with these issues along the way, as have I. I'm dealing with a current client who had a rogue HR director, and she, for some reason, failed to take action when a very disturbing criminal background report came through. She also failed to do any employment reference checks, which was all her responsibility. She then gave an offer to this gentleman, who then started, and all of a sudden things started disappearing from the office, starting with cell phones and wallets out of pocketbooks and things like that. So once this rogue HR director left and a new HR director came on, they did some search. I'll call him a thief. And they went back and they looked in his personnel file. They actually did an audit of personnel files and found, wow, how did he ever get through? An offer letter went out that was signed by the HR director rather than the CEO, and that was also problematic because she went rogue. She really just kind of took over and thought she had this unfettered authority to start making these decisions, irrespective of all of these safeguards that they had in place to do the criminal background check, to do she just neglected to do it. So now we're dealing with some liability issues as a result. So always fun stories we have to share. So moving from the application, let's talk about, and this is probably going to be the meat of our discussion today, criminal background checks. Can you tell us how you conduct criminal background checks, starting with where you find information?
Sure, sure. Let's start first with crucial identifiers. I think that's important.
Sure.
lot of people think that the Social Security number is used in the criminal justice system. It is not. So when we do a background check for criminal convictions, we absolutely need name, address, and date of birth.
Okay.
Those three identifiers should match.
Including all maiden names, AKAs, aliases.
Yes, yes. The more names, you know, if someone has a former name and it's within the time period that you're doing the investigation, we need to know that. If we go to search for Mary Smith and she was Mary Jones when she committed the criminal conviction, that's going to affect the
So you mentioned time period. Will you talk about that now, or do you?
We can talk about that now, or we can talk about it later.
Yeah, whatever you want to do.
Okay.
You can save it, or you can.
Well, let's stay on this slide.
You got it
for now. Okay.
You got it.
And then and let's just talk about where they're found. Criminal convictions are started by the state's attorney at the local level and the federal district attorney at the federal level. So those are where the convictions, the files, the processing, the proceedings are all most accurate and they're most up to date. So whenever you move away from the local jurisdiction, the county courthouse or the federal district courthouse, you begin to sacrifice timeliness and accuracy of the record. So we believe it's always important to primarily go to that local level.
Go right to the source.
Go right to the source, and then we'll talk a little bit about databases. Those can be used as supplemental tools to supplement the criminal conviction search. And so are there different types of criminal convictions? They're primarily felonies and misdemeanors, and also some other types of verdicts. You can have a verdict such as being placed on probation or deferred adjudication or paid a fine for a crime that might not. So it's important to have that question worded such in the application. That's where Offutt Kerman can come in and help a company draft that. Then arrest records, a lot of confusion about arrest records.
Huge topic right now.
And the EEOC says it's okay to consider arrest records if the underlying conduct of that arrest is going to impact the job responsibilities of that particular position for which they're hiring. And the EEOC has some examples in there. They talk about a person who was an assistant principal and was arrested for inappropriate conduct with children, and nothing had happened from that, but the school was legitimately allowed to investigate the conduct, and it impacted that person's job description. Another example that's in the EEOC is if you're hiring someone to work in a warehouse and they're under supervision, they have a DUI in their background, not really affect that.
It's not. It wouldn't seem to be relevant.
Right. But if you're going to ask that person to drive a bus and they have a DUI, then it does. So that's the type of consideration that employers need to make.
So let me pick up on that for a moment because the overwhelming advice that employers are getting out there is do not ask applicants on the application form whether they have ever been arrested. You can only ask about convictions. So I think that's accurate. You can stand by that on an employment application because you don't have 5 different employment applications where you give one to a driver, another one to an executive, another one to a clerk. Companies only have one application, employment application that they give to everyone. So I stand by that general advice, which is, on the application form, you can only ask applicants about whether they have been convicted, and then if the answer is yes, you can ask them to give a little bit of an explanation. Going forward, the EEOC guidance says you should probably include a little policy statement on the application that says even if you have been convicted, it does not preclude you from employment with our company. The other thing I wanted to mention is that if companies are government contractors, or if an applicant is applying directly to the government for a job, the government can ask about your arrests. They can ask pretty much anything they want because they're the government, and the rules they make for others don't always apply to them. So if a background check comes back and there are arrests, then of course the government can preclude a government subcontractor from working on a site. And of course the government could also reject a direct applicant for employment based on arrests only.
Right. Thank you for clarifying that.
Yeah,
we
sure.
will report arrest records in the process of doing a criminal conviction search.
Mm-hmm.
So,
good
point.
And so let me ask you this. So in your experience, Jim, when someone has not been convicted, but they've had several arrests, do you advise companies on what to do in that case?
We send them to you. We will report arrests that we find within the time frame that we go back, if it's 3 years, 5 years, 7 years, and let the company
make the ultimate decision.
We're not in the business of
providing legal
services.
Legal,
right.
Got it. Okay. So oh no, we're not. We'll go back. Sorry, we're still on the databases.
Yes. There, a lot of people think that there's this super duper database on the web that's out there, and you just have to log on to the internet and find criminal convictions, and it's just not true. There are nationwide databases that can be an excellent supplemental tool to doing a background investigation, a criminal conviction investigation on someone. And what you want to do, we have done some surveys and have found that our clients that use that nationwide search as a supplement tend to increase criminal conviction hits 12 to 15%.
Wow. Because
you have someone who's lived and worked in Maryland for 15 years, but they went to Atlantic City and robbed a casino. Well, hopefully, you know, that criminal conviction is there at the level at the in that other jurisdiction. So should they be the sole source? No, they should not. They should be used as supplements. As I said earlier, you always want to go to the local jurisdictions where the convictions are housed.
So this is what you do. So someone who says, Jim, I want you to handle my company's employment background checks. So then what would they give to you? They turn over to you an employment application, a resume, and you kind of run from there, assuming everything is signed off and acknowledged that you have the authority to do that.
Depending on what's in their package, we will take that information and then do the background investigations that they want.
Okay.
A company can have one package. They can have 10 packages.
I see. So a package means that you might only do backgrounds in checks in Maryland?
No,
or is it regional?
A package may be by job. So, for example, you may have a package for warehousemen, people in your warehouse, and then you may have a separate package for your vice presidents.
I see.
Or your presidents.
Okay.
So one package will be much more extensive than the other package. And hopefully, you know, we'll get to Freeman, and that's one of the things they did that thwarted the EEOC's challenge.
FBI fingerprinting database. Tell us about that.
Yes. The FBI fingerprint database, a lot of people think that is the gold standard and that there are no errors.
Right, because they use it for teachers, child care workers, healthcare workers, nurses, doctors, hospital.
Right.
Right.
Right. And the Washington Post recently did a survey of information in the FBI database and found that as much as 30% of it was inaccurate. And when I say inaccurate, what I mean is that if you look at the way information gets into that database, you've got police entering arrest records on people. Anyone can be arrested for anything.
Sure.
So you've got this arrest record in there, but there's no
follow-up.
There's no follow-up. You don't know what happened to that particular action, so the information in there really can't be used. So when you talk about the FBI fingerprint database, you just have to be careful of the information you get from it. You have to use it properly.
So it's somewhat accurate then.
Somewhat accurate.
Somewhat accurate. Scary.
Right.
Okay.
Right.
70% accurate. Okay. So talk about the structure of a criminal conviction search.
When you talk about doing a criminal conviction search, you have to decide on the number of years of addresses that you're going to go back and search. Remember, we talked about where these convictions are housed. So if someone lived in Maryland for 2 years, moved down from Pennsylvania 2 years before, and lived in Texas the prior 2 years, your package should have a standard number of years that you're going to go back and do searches on. So that's one thing to consider. We talked a little bit earlier about names in a criminal conviction search and how it's important to have a name. And if someone has a conviction under a different name.
Sure.
So.
And then how can you verify that? I mean, then you have to match up the dates of birth, or I guess because Social Security number isn't
Social Security
a part of it.
Is not used.
Yeah.
Is not used.
You'd have to look at commonalities between
those three identifiers. Must match before we report a hit to someone. And then when you talk about verifying, you had a question about how do you know. The use of trace reports, supplemental address reports, help in terms of finding out if an individual has had an address in the background or perhaps a former address in the background. If they have an address in Pennsylvania and they know a criminal conviction's there, they're probably not going to tell you.
Right.
So the use of Social Security trace reports is, we think, important in terms of helping to round out that search.
Good point. A question came up prior to the webinar, and I get this question a lot from clients, and the question is, particularly for companies in Maryland, the Maryland companies rely on the Maryland Judiciary Case Search website, which is a website that reports arrests and convictions and the current status of what's going on with someone's prosecution, criminal prosecution, and also civil cases, that if someone is involved in a civil case. And the question is, listen, all we're doing as part of our background investigation for our folks is going onto the Maryland Judiciary website. Should we be doing more? Is that enough? And I'll throw that question over to you.
Sure. The information on the website is a couple things about it. There's no longer the day and month of the birth date, only the year. So there are some situations where just looking on that website is not going to give you enough information to make what we call the adverse action against the individual. So you need to take care if you're using that. If there's any doubt, you need to, again, as I said earlier, go to the county courthouse to do some additional investigation. So it's a shortcut that if it's done incorrectly can burn you. So,
can burn you.
Yep.
There you have it, folks. There's the answer. So a lot of other times reading, even for myself, I'm not a criminal lawyer, so I see all of these criminology terms. Can you talk about what they are? Because I think folks see them all the time. They make assumptions, and they might not be accurate.
Well, there are a lot of terms.
Yeah, a lot of terms. We only picked two here.
That we only have two here. We do have a website resource there that someone can use to research a particular term, perhaps that they're looking at. But basically, nol pros is just an indication that the case against the individual was dropped by the state's attorney.
We don't know why.
So we don't know why. And then the other term that we have up there is stet docket, and that just means that it's inactive. The prosecutor doesn't think that the chances of a conviction are likely, so it's just out there waiting for them to act on.
And they
So,
could be hanging out there for years.
for a long time.
Mm-hmm.
For a long time.
Mm-hmm.
So again, if there's an indication of that, we talked a little bit about the arrest records. A person should consider the nature of what that charge is and whether or not it applies,
Mm-hmm.
has relevance to the job that
Absolutely.
they're being hired for.
Good. Expunged criminal records. So situations where a record has been expunged. So, okay. So just so everyone is clear before we kind of get into the slide a little bit, Maryland based on an expunged record. And there are monetary and also imprisonment fines that can result here if the company is making these types of decisions. I can tell you I've never really seen a decision based on this, but there can be situations, of course, when an individual's record should have been expunged but wasn't expunged, so it will come up on the background check. And so what happens in a case like that if it does come up, Jim?
The individual should be able to provide some court documents that indicate the record should have been expunged. Typically, that type of situation comes up with using databases because, as I said earlier, the information at the courthouse is up to date and timely, but it may have been reported to a database and not taken out of the database.
Sure. That's a good point. So legally then, if an employee is rejected or terminated and then says, whoa, that's not right, that possession of marijuana charge when I was 16 years old should have been expunged from my record now that I'm 45, and that 45-year-old then comes back and to the company and says, look, here is the paperwork that shows, it should have been expunged. It was, in fact, expunged. The judge stamped it, signed it. The motion was granted. That was a court error. Then the employer should either return the employee to work legally or can face this fine or imprisonment. Or alternatively, if it's an applicant who's coming back with this paperwork saying, no, really, the expungement should have been noted, then the company should continue to consider the applicant for the position, assuming the position is still open and the candidate meets all the other qualifications. So I wanted to be clear about that. Another meaty topic now, moving on to, we're flying through, we're doing great. We're doing great on time. The EEOC guidance on issuing criminal backgrounds. So in 2012, in fact in April 2012, the EEOC issued guidance about the use of criminal background checks because in their opinion, employers were consequently using these background checks and discriminating against certain populations. So let me give you a little bit of background. I'll read or summarize here from the 52-page EEOC enforcement guidance talking about this issue. And their justification for coming out with this guidance is because they say in the last 20 years there's been a significant increase in the number of Americans who have had quote-unquote contact with the criminal justice system, and consequently a major increase in the number of people with criminal records in the working age population. So arrest and incarceration rates are particularly high for African American and Hispanic men. African Americans and Hispanics are arrested at a rate that is 2 to 3 times their proportion of the general population. So assuming that current incarceration rates remain unchanged, about 1 in 17 white men are expected to serve time in prison during their lifetime. Let me repeat that. 1 in 17 white men are expected to serve time in prison during their lifetime. And the service of time doesn't mean that they're convicted. It just means service, jail time. By contrast, this rate of 1 in 17 climbs to 1 in 6 for Hispanic men and 1 in 3 for African American men. So the EEOC, based on these statistics, has become increasingly concerned that the company's use of criminal background checks in hiring decisions will have an unfair impact on African American men and Hispanics compared to the rest of the population. And I wanted to point out that there is some, as I mentioned, there is some legislation that's being proposed that companies shouldn't be using criminal background checks in their hiring decisions at all, which I don't think it's a very good idea. You, Jim, don't think is a very good idea. But then, interestingly, the EEOC, who's put out this guidance and is probably a proponent of eliminating criminal background checks, performs background checks on 90% of their own applicants. So what I say is it's good for the goose. If it's good for the goose, it's good for the gander. So the EEOC talks about disparate treatment discrimination in the use of criminal records. And their concern is that employers will be violating Title VII. Title VII is a federal law that the EEOC administers and is responsible for enforcing, investigating claims of harassment or discrimination on the basis of a protected classification, including race and including national origin. So here's an example that the EEOC brings up, and they say, John, who is white, and Robert, who is African American, both recent graduates of the same university, similar educational backgrounds, skills, and work experience, each pled guilty to charges of possessing and distributing marijuana as high school students, and neither of them had any subsequent contact with the criminal justice system. After college, they both apply for employment at the same company, which after short intake interviews obtains their consent to conduct a background check. Based on the outcome of the background check, reveals the drug convictions. A representative of the company says with regard to the African American candidate that, quote, we can't afford to refer these drug dealer types to client companies, yet when they talk about the white applicant, they say, well, John was just young at the time, and his conviction, isn't relevant now because, he hasn't had any contact with the criminal justice system. So, in that type of scenario, the EEOC is concerned that race here is the only factor that would drive companies' decisions in hiring. So, Jim, I know there were 2 recent cases I'd like you to talk about that involved the EEOC, where the EEOC prosecuted these 2 different companies. One is BMW and one is Dollar General.
Yes, both are examples of what companies should not do. I don't have much sympathy for BMW and Dollar General in these 2 cases, frankly. The BMW, there was a company that was providing parts to BMW called UTI Integrated Logistics. There was an individual working for that company, had been there for years. Mm-hmm. I can't recall the number of years, but it was more than 7. Years. Mm-hmm. Then there was a company that bought UTI Integrated Logistics. They had a blanket exclusion policy for criminal convictions. So this individual who had worked, had a stellar record, proven himself, all of a sudden was asked to leave because of this criminal conviction, and he brought the action. So that's an example of what a company should not do. Mm-hmm. They need to take, as you mentioned, these types of considerations when making these decisions. Dollar General, there were 2 individuals there. One person had a criminal conviction in her background 6 years ago. She had had a good record at her prior employer for the past 4 years before applying for Dollar General. She was dismissed, was not allowed by Dollar General to present the case that she had a good record. She had made amends. She had turned her life around. And the other action involving Dollar General was they just did the criminal conviction. They told the individual they had a criminal conviction, And according to the Fair Credit Reporting Act, the individual should have had a chance to say it's not me.
Mm-hmm.
They never gave that person a chance to do that.
Mm-hmm.
So
a lot of violations.
A lot of violations there. In contrast to what Freeman and PeopleMark did,
Mm-hmm.
Freeman and PeopleMark were just classic examples of doing it right, and thwarting the EEOC's actions.
So, you know, a lot of times you have good facts that make good law. Other times you have bad facts that make bad law. But as you mentioned, there is another case. And by the way, so the BMW and Dollar General, those cases were decided what year? Do you know? Was it 2013 or was it 2012?
I'm not sure.
We're not sure. Okay. In any event, you know, I'm sure it had to be in 2012.
Okay.
Yeah, because or early 2013, because I want to talk to everybody about the Freeman case, which Jim mentioned. This is a case decided by Judge Titus in the U.S. District Court for the District of Maryland, which is right down the street here from us. Really kind of put the EEOC in its place, which I think was important because they probably were feeling a bit emboldened after their victories in the Dollar General and BMW cases, and maybe thought, well, you know, we're just going to go after anybody we want to, and look at us and how successful we are in, you know, beating down these companies. Well, they picked the wrong company to go after, and they also were made a lot of mistakes when it came to analyzing the data, and frankly, they really had no primary case other than to just say, well, your policies are discriminatory, and yet they couldn't point to one single policy, one sentence, one you know, background check they did that was incorrect. Let me give you a little bit of background because I think it's important to know the facts of this case and to apply the facts. So Freeman is a national event planning company. It employs about 3,500 full-time and 25,000 part-time and seasonal workers all across the United States. Like many employers, they have experienced problems with folks that have embezzled, they've stolen, they've used drugs, they've engaged in workplace violence. So in 2001, Freeman began conducting background checks on applicants so it could better evaluate important things like trustworthiness, reliability, and effectiveness of their prospective employees. The background checks, as they explained to the court, were designed with 5 goals in mind. Again, very reasonable. 1, let's avoid exposure to negligent hiring, negligent retention lawsuits. 2, let's increase the security of our assets and employees. 3, let's reduce liability from inconsistent hiring or screening practices. 4, let's proactively reduce the risk of employee-related loss. And 5, let's mitigate the likelihood of an adverse incident occurring on company property that could jeopardize our customer relationships. I mean, these are all very reasonable. So, you know, the case goes on and talks about how they conduct background checks, and particularly for credit checks, they only are doing credit checks for employees who have access to client or company credit card information. They're handling money, checks, or similar valuable items. They have certain budgetary authority, or they have authority to make agreements with respect to customer invoices or purchases from vendors. And so the EEOC decided that they were going to go after Freeman. Not really sure exactly why. And so the EEOC did its own preliminary investigation, and probably how this came about is because I remember how it came about. Excuse me. An African-American woman applied to Freeman for a job, and she was denied the position. She goes to the EEOC and she files a charge of discrimination on the basis of race. The EEOC starts conducting this investigation. Freeman says, okay, well, fine, we'll limit it to the office where she applied. we'll give you information on our hiring statistics information. EEOC said, no, we want information about your hiring practices, across the nation. Freeman tried to limit it. EEOC got ticked off. Ultimately, they then filed this lawsuit. So the EEOC was the plaintiff. There was not the individual former applicant who was the plaintiff. The EEOC was the plaintiff. And the court, after some discovery, which is the sharing of information and taking of depositions and reviewing data, the court granted summary judgment, which meaning the court dismissed the lawsuit in favor of Freeman on several bases. And they found that, number one, the statistical analysis presented by the EEOC to support its claims were premised on a flawed database. So the EEOC's expert disregarded information produced during discovery and instead based his analysis on data provided during the EEOC's investigation, which took place years earlier. So the statistical analysis information wasn't accurate. They excluded information, and then in addition to excluding information, they cherry-picked data that they thought would be more favorable to finding that Freeman discriminated. And then finally, and as I mentioned earlier, the EEOC failed to identify any specific policy or policies that alleged adverse impact. So, the EEOC, I think, was emboldened by its victories in the prior two cases and then just moved forward without having all of its ducks in a row and without doing a really good analysis of the facts, because had it done a good analysis, it would have seen that Freeman did not discriminate across the board, and that it was not this kind of nationwide discriminatory practice that was going on. So I think that's a really important case. It was decided in August of 2013, so it is precedent. It's a published decision. Something to keep in mind. So if anyone has any questions about it or wants me to send them a copy of the case, I'm happy to do so. Moving on. Whew, that was a lot of talk about that. But let's move on to employment references, Jim, because I know a lot of times companies are instructed when they're called, when they receive the call, oh, tell me, did Jim Randisi work here? What was he like? How long did he work for you? Et cetera, et cetera. And then all companies are giving out is like name, rank, and serial number. They're kind of tight-lipped about it. So how can we get information from prior employers? Right.
We hear that all the time. Why should we call prior employers? And this slide contains some bullet points of reasons why we think it's important to call prior employers. You're going to eliminate employment gaps. Companies will almost always give you hire date and termination date, which is good to know. They may be hiding time in prison if they said they worked an extra 6 months somewhere. It can help search for criminal records. If someone worked for a company that has headquarters in Baltimore, but they have a regional office in Phoenix, and they just told you they worked in Baltimore and didn't tell you they worked in Phoenix, they may be hiding an address where they have a criminal conviction. You're going to hire based on verified facts. If you're hiring what you think is a manager and they tell you they were a manager in the prior position, but they were really an assistant manager, that's going to be uncovered. You mentioned earlier about due diligence. They didn't call prior employers. It allows you to demonstrate due diligence, which is important to avoid negligent hiring. A lot of people think that this is just about finding dirty laundry on people, but if you're doing an investigation and you're investigating people, you may find good information. So that's another reason. You're going to determine that the skills, education that they allege are a good match.
Can we back up?
Absolutely.
What do you consider good information when you say good information?
Well, every time we do a prior employment verification, we try to get to the supervisor. We have found that about 25 to 30% of the time we do. So you may talk to a prior supervisor and say that Tom was an excellent candidate, excellent employee, and you'll find out good information rather than just finding out bad information.
I love the calls that folks make, and they get to that real loose-lipped person on the other end of the phone, and that's when I thought you were going to go to good information where someone will say, oh my gosh, this was the worst employee we've ever had. She was always late and she got into fights with people at the office.
No, by good information, I mean good information.
Well, and I've seen, another definition of good information is a lot of juicy information that factors into maybe we don't want to hire this person because she was, texting her boyfriend all day long when she was supposed to be answering phones, or, plenty of things I can come up with, but I think you listeners understand exactly what I'm saying.
Yes.
Okay.
And we talked earlier about if a prior employer doesn't respond, it's giving you information about the individual.
Telling.
And you're going to talk a little bit later about negligent referral. Basically, if you don't call a prior employer, and that individual that you've hired engages in conduct that injures third parties, and they were engaged in that behavior at the prior employer, you have no action against that person. If the behavior at the prior employer was factual and honest. So I know you're going to be covering that later, but
I will.
There's no way to defend against to enable the tort of negligent hiring unless you call prior employers.
Absolutely. Absolutely. And another topic I know that's big on what you do at Randisi and Associates is drug and alcohol testing. Can you tell us some points and give us some pointers for implementing these types of testing procedures? Because I know this is really important and probably why everyone's been sitting on the edge of their seat just waiting for this topic to come up.
Okay, well, we'll try to answer everybody's questions. The first thing is that an employer should have a policy. It should be distributed and signed. Can't tell you how many times companies will call us up and we ask them, well, do you have a policy? And they say they don't. In terms of specimens, you've got urine, oral fluid, hair, breath, and blood that are the available specimens.
And there used to be, you said hair in there, didn't you?
Yes.
Is there an issue with hair that you've learned of recently?
Well, with hair, you have to be careful in the sense that hair will go back, depending on how long the hair is, it can go back 30, 60, 90 days if it's 3 inches long. So if you can't take action against someone for current illegal drug use if they did it 60 days ago. So that's one thing.
I think that's an interesting point.
To be aware
we talked about that. Yeah.
And also you need to be aware of the state laws in which you are doing business. Maryland, we talked about the fact that for employment purposes, breath is not allowed as a specimen. Now, if an employer is governed by Department of Transportation regs, breath is allowed, and that certainly trumps the state laws. But a person needs to be aware of the laws of the state that they operate in.
And breath can't be used because
in Maryland
you can't retest it. Right.
Exactly.
It's gone.
Exactly.
Right.
Yes.
Whereas other specimens, urine, blood, hair, because many times, well, the law in Maryland is such that if there is a positive for drug or alcohol, that the same specimen can be retested, which is why there's an issue with breath and testing for alcohol on breath. But it has to be that same specimen. I can't tell you how many times I've run into extremely upset applicants who say, I want to get my specimen retested. I want to get my specimen retested. Well, it's very expensive to have it retested, and it's a couple $100s. And then even more.
We recommend 200.
And even more if you want to test for different types of chemicals. So it's going to be very expensive.
Right. And the reason is it can't be tested at the same lab that gave you the initial.
Exactly.
So that's why it's a very manually intensive process to maintain the chain of custody form.
Thank you.
So, yeah.
Okay. We were on positive ROI for drug testing.
Yeah, ROI. Sure. We talked a little bit about the Society for Human Resource Management. They did a article back in 2006, a little dated, but they found that an illegal drug user will cost you $11,000 to $13,000 because of the reasons you mentioned earlier: workers' comp, accidents, time off. and increase use of your health insurance program. They use your health insurance 3 times more than someone not using illegal drugs.
Interesting.
And there is if you go to the Quest website, there's a drug testing calculator. You can plug in the industry you're in, the number of employees you have, and it will tell you the return of a drug testing program, return on your investment. And then employee performance and drug testing. I can't tell you how many times, Laura, we get questions. We'll have a call from a company or a client, and they'll say, Tom has been making a lot of mistakes lately, and his eyes are watering, and he's causing accidents. We want to do a drug test. But a drug test may or may not work. It may uncover positive. So the emphasis there, and what I wanted to emphasize, was that if someone's performing poorly, you need to manage poor performance. Drug testing is not the be-all, end-all to catch people.
Right. And I know I recently had a new client say to me, well, I absolutely want a drug testing policy in my employee handbook because I want to give proof if someone is, using drugs. And I, tried to talk to him and explain, well, you also have to manage poor performance. You have to, discipline, counsel, coach accordingly. You can't just, as you said, use this as a be-all, end-all for getting rid of someone.
And I skipped over the most effective time, and I know that we're coming up to the end here. Quest analyzes 5 million, 6 million drug tests a year, and they analyze those results 35 different ways. But I wanted to let people know that pre-employment, about 3.7% of pre-employment drug tests are positive.
Okay.
But in a random situation where an employee knows he works for an employer who will be conducting random, those random positive rates are 5%.
Okay.
So a company gets 40% more bang for the buck. They should do both, but we understand that dollars are tight sometimes.
That is really interesting.
Yeah.
Yeah.
And then
folks aren't doing the cleanses or whatever, all these drinking all these solutions during work. They're confident in their position. They're not going to be tested.
So just briefly then on zero tolerance, sometimes companies think that the best thing to do is to get Joe out of the workforce if he tests positive on the first time. And that sounds okay, but it doesn't make business sense for a number of reasons. It costs a lot. Assuming, we talked a little bit earlier about performers, assuming that he's been performing great in your workforce, replacing him is going to be very expensive. And we've had situations where zero tolerance was the policy, and the president, we had a bank, and the president's son was working part-time during the summer, got pulled for random, and tested positive for marijuana.
Yeah, I mean, that's challenging, but, that situation is challenging because of the relationship there between the father and son of the company. But, what about a situation where you have a high-level employee who's been working for 35 years, suddenly, say her husband passes away, or she loses a child in a horrific accident, and she's in a depression, and she starts drinking. Is zero tolerance policy really the right policy to enact here, or is that kind of an employee relations suicide where, if you terminate that woman who's just, already has a terrible personal issue that she's experiencing, what are the other folks going to think about about what the company did? So
best to use an employee assistance program and help that person address their substance issues. The next bullet point about positive 6 months ago, we had a situation where we had a client, an individual who had applied for a job was positive 6 months ago. The individual reapplied, and they wanted to know whether or not they should let the individual apply, and the answer is yes. The person can reapply. Just because they tested positive 6 months ago does not mean that they're not allowed to reapply. And that last bullet point, is just a point I wanted to make about
Very good
current
point.
illegal drug use.
Mm-hmm.
There are a lot of questions about states with the marijuana laws, and what do I do if someone is positive? I don't think, you could correct me if I'm wrong, but I don't think there's a court in America that will prevent an employer from taking action against an individual who is under the current influences of an illegal drug.
Right.
So
and that's another good point, just to add to that, and I thank you to those. I know it's 1 o'clock, but we're going to keep going because I think we have some additional information to share with you today. But as far as current illegal drug use, for those of you familiar with the Americans with Disabilities Act, the Americans with Disabilities Act, the ADA, says the same thing, that someone who is currently using illegal drugs are not protected under the ADA. They do not have a disability. It's different for someone who has a history of being a drug addict or an alcoholic, but someone who's currently using is not covered. So let's talk about some free steps that companies can take.
Everybody likes free.
Everyone
right?
loves free.
Everyone likes
Who doesn't love free? Right.
Well, yeah, here we've just got some things that you can do. Just have a clear statement on the application that information must be truthful, and any material misstatement or omission can result in removal from the hiring process. For Freeman, we talked a little bit earlier about Freeman. They had that.
They did it
and
right.
That was perfectly. Again, you can just display some signs that background checks and drug testing are conducted at your company. And the last point, it's amazing the steps companies will take to vet and screen the CEO or the senior vice president, but yet they'll let a cleaning company come in and not insist that cleaning company, vendors coming into their premises, have screened and drug tested their employees, and that's not going to cost you anything to insist on that. There are a number of
That's interesting.
there are a number of cases where cleaning, employees of cleaning companies have come in and done some damage in terms of information that they stole. So.
And I've seen it sometimes the opposite, where companies are trying to show a new CEO or a new CFO how much they trust them, and they don't run a criminal background check, which I think is a huge mistake.
Right.
I think trust is a two-way street, and you don't earn it until you earn it. So I think you treat everyone the same, including even vendors, where you can insist on it from those who are vendors for your company. So we're done with the free steps. Let me very, very quickly talk about the Fair Credit Reporting Act. It is a very comprehensive 130-page long act that really explains how employers, part of it explains that relates to employment, explains how employers are to use these reports, and it provides really helpful templates that employers should be using to communicate negative information on someone's reporting credit report, which would influence the company's decision not to hire someone. It also provides really good guidance to applicants and employees on how to challenge an inaccurate report. The other thing the Fair Credit Reporting Act says is that every person is allowed every year one free credit report. So it's really important, especially now with you've heard in the news how right before Christmas, Target store was targeted. Target was targeted for stealing credit card information. So the Fair Credit Reporting Act allows everyone to go and have one free credit report a year. So really important. Now, the Fair Credit Reporting Act does not apply to some of the things that you do, some of the background reports that Jim does. Some.
Drug testing is really the only report that does not, the activity that does not apply. Really anything we deliver as a consumer reporting agency, criminal conviction, prior employment, is covered by the Fair Credit Reporting Act. So that sometimes people will say, well, you're not giving me a credit report. Well, it doesn't matter. It's a consumer report.
Thank you for that clarification.
Yeah.
That's important.
So the adverse steps need to be taken with this.
Yeah. And for those companies that are doing these background checks themselves and not using a third-party agency, which Jim wouldn't recommend, they are not subject to the Fair Credit Reporting Act. So they can do reference checks. They can go look on the Maryland Judiciary website. They can even go look on public websites, social media sites, and find photos and background information on these folks, because those searches aren't subject to the Fair Credit Reporting Act. Very quickly, the Job Applicant Fairness Act is a Maryland law which took effect in October 2012. It prohibits employers in Maryland from using a job applicant or employee's credit report to determine, number one, whether to hire a job applicant, whether to terminate an employee, or the rate of pay or other conditions of employment for an employee based on what their background report says. So, by the way, the law does not apply to companies who are required by law to consider a credit report or a credit history for the purposes of employment. Does not apply to financial institutions that accept deposits insured by the FDIC, for example, banks, or in some situations, credit unions. It also does not apply to privately insured credit unions approved by the Maryland Commissioner of Financial Regulation. The last thing, I think, on the list of federal acts to discuss is the Federal Bankruptcy Act. Few people know this, but in the Federal Bankruptcy Act, there is a provision that states that government units and private employers cannot deny employment to an applicant or terminate an employee or discriminate against any person who has ever filed for bankruptcy. I know that's come up. I've gotten some calls about that issue in the past, so I thought it was important to include that in here. And the final slide, and then we will dismiss everyone and wish you well on your drive home, is employer liability. And these are really important torts where companies can be liable for not performing due diligence. And let's start off on the first bullet point, negligent referral. And Jim referred to this. So a negligent referral is when you are the former employer, and you as the former employer are not disclosing information or providing untruthful information that results in future harm to a subsequent company. So for example, let's say your employee, Mike, beat up his supervisor. And when Mike's prior employer was asked if there's anything we should know about why Mike left, and says, oh no, he was great. Mike was great, loved him, everybody loved him. And then later Mike beats up someone at his current job, then the person who gave that incorrect or untruthful referral, that employer can be liable for not disclosing appropriate information. Negligent hiring is when a company knew or should have known about something in someone's background that would have otherwise precluded them from being hired and decided to hire them anyway. I have seen this from time to time, and one question that's come up is, for example, we hired someone to work in the warehouse, but they had something related to domestic violence in their background, and had we known that, we wouldn't have hired. But that was 10 years ago, and the guy's still here, and he's a great employee, and we've never had any problems. Now that we're doing this audit of our personnel files, if we wouldn't have hired him then, does that mean we should fire him now? And my answer was, well, it doesn't seem that we should fire him, right? He's proven himself. He works with very few people, domestic violence, history, always a red flag, particularly when someone is, harming someone else.
But that's exactly what the EEOC wants employers to consider,
right?
What you just said.
Exactly, and it's important, because if someone has kind of moved on from that past life or that bad situation, drug use, or hanging out in a gang or with the wrong group of people, and they've rehabilitated and turned their lives around, let's give them a chance. Negligent supervision, of course, is okay. We know that Mike has engaged in this type of activity here at our place of employment. We know he's dangerous. We know he's explosive. We know he's violent. Yet we left him alone in a situation where we weren't properly supervising him. Similar negligent supervision and negligent retention similarly go together. Often in a lawsuit, if one is alleged, the other is alleged. Similar to negligent hiring, I just had a lawsuit that settled when I saw all three of the three middle claims, hiring, supervision, and retention, were claimed. And then, of course, the big one is employment discrimination, and in Title VII and in the state and local human rights offenses that where employers are discriminating based on a certain protected classification, which again, I don't want to rehash, but the EEOC addressed that in its guidance from 2012. So, thank you all. Thank you, Jim.
Thank you, Laura. This was a pleasure.
This was great. Thank you all for staying tuned in. We wish you a great afternoon, and please be safe out there. Thank you for tuning in. We will email you your information about HRCI recertification credit in a couple days. Take care. Good afternoon.